Betsy, thank you for coming.
Sure, thank you for having me.
I almost always start at the beginning with our guests, and so I want to do that with you and say, you know, tell the students how it came about you decided to be a lawyer.
Well, in undergraduate school, I majored in political science because I really enjoyed political science, and I had a mentor who really influenced me a lot and encouraged me to go to law school. And I really wanted to teach, and he said, I really think you should go to law school. So I took the bar exam and got into law school and did mock trial in law school and just, you know, loved it, loved litigation. My mom said I was made to be a lawyer because I would argue about what color the sky was if I wanted to.
There's a lot of that going around.
Yeah, so she thought I was very fit for being a lawyer, but I didn't know it in college. I just had a political science degree, and what else would I do? But then when I got to law school, I really enjoyed it.
Mm-hmm. You went to law school at the University of Georgia.
Yes.
What did law school do or not do to prepare you for your career?
Well, I was lucky. I had a favorite professor, my torts professor first year, and I ended up taking every single one of his classes. Products liability, medical malpractice, workers' comp. So I knew I wanted to be a litigator.
Who was it?
Professor Tom Eaton.
Okay.
He's still there. And he also, we had a very young mock trial program. Moot court was the thing, but mock trial was brand new. And I got involved in that, and then he handpicked me for an ABA mock trial team. So he was my mentor. And I actually wrote my third year paper. I was not a law review person, so I wrote my third year paper for Professor Eaton.
You mentioned mock trial a couple of times. This is skipping ahead
Yes.
a little bit, but I want to make sure that we talked about this a little bit. You have some history with the high school mock trial. I bet there's some folks in this room who did that.
Anybody in here do high school mock trial?
Yeah, so I told you.
All right. Well, I was the chair, when I first started practicing law, wanted to be on committees and do things, and I did the intra-state mock trial competition, and I think that was between the Georgia law schools. I don't know if they still have it, but it was Mercer, Georgia State, well, Georgia State didn't have a law school then, Mercer, Georgia, and John Marshall, and Atlanta Law School. And then a teacher from Jonesboro came to us and said, I have this vision of a high school mock trial program. And so we were first a subcommittee of the Law Awareness for the Youth. Myself and Warner Fox were the first co-chairs of the subcommittee, and then the next year we were the first co-chairs of the actual high school mock trial committee. And now it's an actual program that's statewide. We are sending a team to nationals next month. We sent teams to nationals the past 20-something years. And I went to the state finals. I started working again at the state finals just last weekend. So yeah, high school mock trial is my baby.
All right, so you were there at the beginning.
Mm-hmm.
How many teams compete now?
How many teams compete now?
Mm-hmm.
Geez, I didn't look that up. I know there were 4 the first year when this all was born in Jonesboro. And now there's districts, there's regions. You know, how many? There were 16 teams at state finals this year, but I think there's hundreds.
Yeah. And that's the point.
Yeah, it's
Yeah,
huge.
it's huge.
We actually have a director, a full-time teacher, who runs the program. It needs somebody full-time.
Well, as I mentioned to the students when I introduced you, you come to this event with a particularly relevant background. And you served on the investigative panel, because the students won't know what that is. You served on the review panel, and they won't know what that is. So we're going to have to talk about that. You've prosecuted lawyers for misconduct. I assume gotten some lawyers disbarred. And you also now represent lawyers who are in trouble. Why don't we start with you describing to the students the disciplinary process in Georgia, because we're going to be using some terms that they need some context for.
Well, the disciplinary procedures get kind of complicated.
Oh my.
But because they've developed various routes. But basically, I worked in the Office of General Counsel at the State Bar of Georgia. And when I first interviewed for the job, I said, is that a government agency or what? And it's the disciplinary arm of the Supreme Court, the Office of General Counsel. And what happens if someone has a complaint, they fill out a grievance form and send it into the state bar. And the first thing the state bar does is send that grievance form out to the lawyer. And I would prefer it if the lawyers came to me at that point, because a lot of grievance, well, first they screen it before it even goes out to the lawyer. There could be a grievance that comes in and we say, when I was at General Counsel's office, this is not anything we have jurisdiction over. For example, my husband's lawyer was really rude to me and called me a bad word. And I think he was just really rude, and I'm going to file a complaint against him. Well, we don't have jurisdiction, the state bar doesn't have jurisdiction over a lawyer's personal conduct, unless it involves a felony or a misdemeanor involving moral turpitude. Other than that, there is no, as the General Counsel's office says, there's no jerk rule. The lawyer can be a complete jerk, but we don't have jurisdiction over that.
By the way, the students are aware that's changing in some states. You know, South Carolina now has a jerk rule.
Well, that gets into professionalism too. That's why we, to try and prevent the jurors from practicing law. But so a complaint could be dismissed as soon as it comes in the door. If it doesn't get dismissed, it's sent out to the lawyer for the lawyer to review. And like I say, I like it when lawyers come to me right away so that maybe we can stop it at that process and say, whoa, there's no violation here. There's just no violation. The problem sometimes is once a lawyer writes their response, it goes back to the state bar, they send that response out to the complaining party, and sometimes it gets into a swearing contest, and at the screening level, if it's a swearing contest, then the state bar, if they can't completely dismiss it out of place, they send it on to what's called the investigative panel. And that's composed of lawyers who are actually investigate individual cases, and then there's some ex officio members, and I don't know the numbers, but when I was president-elect of the Younger Lawyers Section, I was ex officio, president-elect of the state bars, that's ex officio, and there's lay members on the investigative panel, but they don't do the actual investigation. And the investigative panel member then sends out the grievance again to the lawyer, and the state bar will usually say, we think these are the violations, these rules have been violated. The lawyer then has to file a sworn response to the investigative panel member. Again, it goes back to the person who complains, and then the investigative panel member, once he or she completes their investigation, it goes to the full investigative panel, and he or she makes a recommendation, either let's dismiss this, let's see if they'll take some informal discipline, or send it on to the General Counsel's office for a formal complaint to be filed with the Supreme Court of Georgia, and a special master would be appointed to conduct a hearing. And you have the rules of civil procedure, it's just a shortened time frame. And what I have done sometimes is you can petition for voluntary discipline, and if you get discipline at the investigative panel level, if you get an investigative panel reprimand, a letter of formal admonition, those are not public record, they're confidential forms of discipline. And I've been able to negotiate some people that I thought, there may be something wrong here. You have to admit to a violation and say, I admit I did this, but here are mitigating factors. And the ABA has a list of mitigating factors. Or there could be aggravating factors too. So eventually, after the special master conducts a hearing, the special master makes a report, and there's other things that could happen along the way, which I won't get into. This is a shortcut route. But then the special master sends his or her report to the Supreme Court, and either side can request the review panel to look at it before it goes to the Supreme Court to get another set of eyes. The review panel is a similar makeup as the investigative panel, and I believe it used to be that everything went to the review panel automatically, but they've changed recently. But once it gets to the special master stage and a formal complaint filed with the Supreme Court of Georgia, it's very hard to get a case dismissed, although one was dismissed quite recently. The Supreme Court, the special master found that there was a violation, the review panel found a violation, and the Supreme Court reversed, which is very, very unusual and very difficult to do. That's it in a nutshell.
Right. Now, you started your work in the disciplinary process, as I understand, right? Basically as a prosecutor.
Yes.
Okay. And as a very young lawyer.
Yes.
Okay. Tell us about that experience. What surprised you when you first went to work in the Office of General Counsel, prosecuting lawyers for misconduct?
That's a good question. I took over voluntarily the ethics hotline, so I could, even though I'd studied ethics in law school, I didn't memorize the rules. And, but I was surprised that there were so many phone calls and that so many lawyers did try to find out ethics questions.
You may need to explain what the hotline is.
Well, they now have an actual dedicated hotline where you can call in and ask an ethics question. Back in the day, when there were only 4 of us in the office, we took turns, and all the seasoned lawyers in the office were sick of taking phone calls, and so I think I would have gotten the duty anyway, but I liked it because it got me familiar with the rules, and I'm not too shy, as you can tell. So if I didn't know the answer, I'd just say, well, I have to call you back. And that way I got to talk to the other lawyers in the general counsel's office and figure out the right answer. But I guess I was surprised that so many lawyers were actually disciplined. You know, I just thought that the profession was above that. And I think there's more complaints now because the general counsel's office is huge compared to when I started there.
Yeah, the numbers really are shocking. What was when you were prosecuting, is there one case that stands out in your mind that you remember that taught you something?
Well, I don't know if it taught me something. It was just very interesting. Back then, you couldn't resign from the bar, and we were trying to prosecute this lawyer, and he wanted to resign instead of being disbarred. And we had to disbar him. He refused to accept the disbarment. It was very litigious. That was just very interesting. I also remember that we got a large number of complaints from prisoners and those were ones where we really didn't have jurisdiction. You know, ineffective assistance of counsel is not what we deal with.
I lost, therefore my lawyer must have been.
Exactly.
Once you stopped prosecuting, I assume that's when you then began your service on the investigative panel and the review panel.
It was after that, because I went into private practice, and then that review panel, investigative panel were in conjunction with my bar work that I did.
Tell us about that experience, working with the investigative panel and the review panel.
Well, it was just interesting seeing it from the other side, and listening to other lawyers. And I will say this, now that I defend lawyers, I think some of the investigative panel members have gotten more conscientious and will listen. Some people before, I think, were more knee-jerk. Oh, this sounds bad. I don't like what this person did. And I see more of the investigative panel members now giving careful consideration, listening to the lawyers. One investigative panel member said to me, I think it's my job to protect lawyers, not just to, you know, my job's not just to find something wrong with the lawyers. So I think the people that do it take it very seriously. And that's good. Good thing for both of us.
Is it a fair analogy to say the investigative panel is kind of like a grand jury, you know, for this process?
Mm-hmm.
I mean, that they're the point at which we decide whether we're going to send it on or not?
Yes, except the lawyer doesn't get to appear. And that frustrates a lot of my clients, that they don't get to go talk to the investigative panel because they know that they could convince them if they could just go down there and talk to these people.
Right or wrong, they know that.
That's right. That's right.
That they could do it. What's the most common complaint against lawyers?
Unfortunately, and I touched base with Jenny Middleman over at the State Bar before I came to see if it was still the same thing. It's been quite some time. Failing to communicate with the clients, keeping the clients informed. It's a shame. I mean, that, I guess, is one lesson I learned, is just return the phone call. Don't ignore your client. And that surprised me that happens so frequently. I mean, you can even have someone from your office return the phone call or the email or whatever. But keep your clients let them know what's going on in the case, even if nothing's going on.
You have a rule of thumb for them about how quickly phone calls should
I don't, but I try to return every phone call the same day, personally. And that's one of the things, one of the first lawyers I worked for, I did domestic relations for 2 years.
You grimaced when you said
Yeah,
that.
yeah. As a young lawyer, I just wasn't my cup of tea. I think it takes a very special person to do domestic relations and not take it home, not get personally involved. And I was not very good at that. But it can get very litigious. And one of the things that, and there's some lawyers you don't want to talk to. You know, I really don't want to answer the phone if so-and-so's calling because I know I'm going to get an earful. But the guy I worked with, Paul Cadenhead, he told me the most expensive thing on a lawyer's desk is an unreturned phone call. And he said, it could be your worst enemy referring you to a multi-million-dollar case. You just, and then of course it ties into the discipline. If you don't return a phone call, you might get a bar complaint filed against you.
For the really serious disciplinary cases, what's the most common kind of, at least alleged misconduct that we're seeing, and that you're seeing from the defense side?
Well, fortunately, most of my clients were wrongfully accused.
Of course.
They really didn't do anything wrong. Somebody misunderstood. I represented a lawyer. It was tough. It was a friend, but he was doing a loan closing, and the person doing the loan thought he was their lawyer. And the loan closing attorney usually represents the bank, and she was mad at him. And it was a complete misunderstanding. And it got to the investigative panel stage because he didn't call me until then. But there are some people that do get complaints filed against them that really have not done anything wrong. So I haven't seen anything really egregious, but I have read the advance sheets and the Fulton County Daily Report, and a lot of the problems, unfortunately for lawyers, involve alcohol and drug problems that lead to other problems, unfortunately. And it's a high-pressure business.
So what you're talking about there really is the underlying cause of what can turn into,
Yeah.
Turn into types of misconduct. So, for example, client neglect, right? Client abandonment.
Yes.
Can certainly
Yes.
flow from that. Raiding the trust account, right? And there's no quicker road.
No, trust account violations will get you every time, and I don't know if y'all know this, but you have to keep your money in a IOLTA account, anything that's not in your operating account. And if you have an overdraft in your trust account, the bank notifies the bar immediately. Even if it's a mistake, the bank notifies the bar immediately. And that came along after I started practicing. They didn't have that when I first started practicing, and there were so many. I mean, I do, now that you brought back something, I remember doing a deposition of a lawyer who had just abandoned his practice. And then he came back, and we were going through his checkbook. What's his check for? Oh, that was the groceries, that was the laundry. Well, this is your client trust account. Well, yeah, it was easier just to pay it directly. And I was just flabbergasted at that he just thought it was easier to just pay everything out of the trust account. Well, yeah, it's easier, but you're not supposed to do that.
Yeah, my favorite ones are the lawyers that pay their bar dues on the trust account. It actually goes to the bar.
To the bar.
Bar dues, trust account.
Not a good idea.
Not a good idea. Have you represented lawyers who have these kind of underlying problems that you're talking about, alcohol or drug abuse?
I haven't. I did represent an applicant for bar admission who had, he had a DUI in college and I think a minor infraction. It was not even an arrest for having marijuana paraphernalia in his dorm room. Okay. The fitness board to determine fitness wanted a complete history of his alcohol and drug use his entire life, and that's when he came to me. And he was referred to me by another lawyer, and I sent him to a a psychiatrist, to do evaluation to see if he had a tendency for alcoholism or drug abuse. And he passed that test. He got the written certification. He sat for the bar. He passed the bar. He's practicing law today. Yay. But the bar, I didn't know the Board of Determined Fitness had gotten so strict, because those weren't even big things in the big grand scheme of things, that they really wouldn't let him sit for the first bar until he did all that.
So they tabled it, that he actually was delayed, all that evaluation. We do a hypothetical during the semester several weeks ago about character and fitness, and students are aware of that particular process. Have you represented other applicants who go into character and fitness?
I had, a long time ago, I had a lawyer who had had a felony conviction, and he was an older lawyer trying to get into the Georgia bar, and the felony conviction, I believe, had been expunged, but he still had to disclose it.
Sure.
And it didn't, I think one of the arguments we made, I don't remember what the felony was, but the felony did not really tend to affect his character so much as, you know, it wasn't like he was kiting checks, or there wasn't fraud, and it may have been a narcotics conviction, I don't remember, but he was able to sit for the bar. And that's the thing, the Board of Determined Fitness, if you lie and they find out, then you're in really big trouble. I mean, the best thing to do is to be honest, get it on the table, and explain it. You know, I was young, I was foolish, it wasn't a very big deal. I'm okay now, I'm fine, you know. And they do, you know, readmit people to the bar too that they disbarred. I've seen several readmissions lately, and that's not easy because you have to go through the fitness process all over again to be readmitted. So I can't imagine doing that today, having to redo what I did 30-something years ago.
What's it like representing lawyers?
Sometimes it's difficult. I gave an engagement letter to one lawyer, and she gave it back to me marked up. And
Of course she did.
yes, of course she did. And I wrote her a letter and said, I decline to represent you. And she called me and said, why do you decline to represent me? And I said, well, I don't like these changes you made. And one of them was when I have, bless you, when I have clients, in litigation clients, that one of the things we say in our engagement letter is you will not call the judge directly. And yes, some clients do call the judge directly even though they're not supposed to. I haven't had one, but someone on the other side has. And I put on my engagement letter that she would not contact the investigative panel member or any of the members of the review panel directly. And she scratched that out. She said, well, I want to be able to call them. Like I said, they want to be able to talk to them. And I said, no, if I'm representing you, I talk. So you have to gain control right away because, you know, we're talking some equally strong players. But aside from that, I like it because I understand how the bar thinks and what they're looking for. And a lot of times lawyers come to me and they're focused on the wrong thing. This is what I want to talk about, but this is what the bar really cares about. You know?
Just tell us about that. I mean, for example, if you have a client who said, you know, this is what I think happened, and this is what I think is important, this is what I want to tell them about, but you know better what the bar is really concerned about. Can you give us an example of that?
I wish I thought of one before I came. I don't know if I can offhand. I know I've had to refocus a lot of lawyers into what was really important. I think they're really concerned with this conflict, not how you maybe it's how they think, it's how I handled something. It's not really how you handled it, it's just that there was a conflict here or something, but I can't think of any specific examples, but I know I've had to do that before, because I'll typically, when I get a lawyer comes to me, I'll have the lawyer write the response, which I will then mark up, of course. But that's because I want the whole picture. And then I'll put it in a form that will, if I don't understand it, how is the investigative panel going to understand it? Because they're just all over the place. We need to focus, focus, focus. And maybe that's what it is. They just want to explain away everything. And I just try to narrow the focus as to what is really at issue here.
do a lot of these really have their roots in basically just a fundamental conflict with the client, just a difficult client, and the lawyers didn't handle it right?
Sometimes, yes. And then I've had a conflict with a lawyer and other lawyers in DuPont. She employed a disbarred attorney in her office. That's a whole other issue. But everybody sort of ganged up on her and complained that this disbarred lawyer was practicing law. And that was an instance where I had multiple different cases going on. And I was fortunate enough to have a very good investigative panel member who let me consolidate them all into one. But she didn't like getting that investigative panel member, man, but I thought that was pretty good.
What's the worst result you've ever had to go through with a client in the disciplinary process?
With a client, I had a good friend who I had to recommend because he would not and could not admit to having done anything wrong. Go ahead and say, okay, State Bar, file a complaint to the Supreme Court. And then it becomes public record. And then it's out there. And I hated doing that, but he didn't do anything wrong, and ultimately we got that case dismissed with no discipline at all.
But a big part of it sounds like how you define success in these cases is keeping it from being very important to your clients.
Yes, that's a good point.
Now these cases with the bar, we've been talking about disciplinary cases, they deal with the rules of conduct. Okay? So they deal with ethics in a formal sense. And students here know that there are such rules, but they're first year students mostly. Most of them have not taken the class in the rules of conduct. That will come later. What this class is about professionalism. And so I was wondering if you could tell us how you perceive the difference between those two things and what professionalism means to you.
Well, it's interesting you say that because the Chief Justice's Commission on Professionalism came about when I was a young lawyer, and we didn't even have a professionalism ideal and aspirations, but it came about, and I think the State Bar rules of professional responsibility are what you have to do. What you have to do so that you don't get in trouble, what you can and cannot do. Professionalism is more than that. It's returning the client's phone calls, even if you know it's a difficult client or a difficult lawyer. Being polite. I was just at a seminar and there was a professionalism segment, and one of the panel members said she has to videotape every deposition that she has with a particular lawyer because he can be so abusive. And I can't imagine that. I don't know anybody like that. But
I do.
well, and so that's professionalism, not having to have a videographer in every deposition because you're so abusive. But I just find that appalling. But just being polite, being civil. When you have a very contested case, when you get out of the courtroom, when you get out of the deposition, you talk to each other politely. The Atlanta Bar has a really neat thing. They have take your adversary to lunch, the litigation section. And they have a competition. And you see how many times you can take different adversaries to lunch, and the winner gets a prize. But
probably lunch.
Yeah, probably a lunch. But I think that's what professionalism is about. We're a profession. We're not just an occupation. We've got high standards, and we do what's right.
In your experience, why do lawyers not live up to that? But what's driving that kind of disparity?
I guess it's just their personality. And some lawyers are very effective by being hard-nosed, emphatic, litigious. One of my very first brand new domestic relations lawyer cases, I went to a deposition all by myself, and the lawyer on the other side I stated an objection, and he was all over me. And if I hadn't had the guts to just say, stand my ground and not stoop to his level and start yelling back at him, if you want to call the judge and deal with it, we'll call the judge, but I'm not changing I'm taking away my objection. And
How did that feel in the moment?
scary. I was a little shaky, but when I was done, I felt really good. But it's hard to stand up to someone who's older than you, been practicing law longer than you, and just berating you. But when you get out of the moment and you've made it and you've stood your ground, it feels pretty darn good.
How did you know to handle it that way?
I knew what the law was.
Okay.
I did my research, and I had the statute right there. I was prepared, and that is one of the things that I found. If you're prepared, then you have the confidence, and you know you're right. Then you can show him you're right, him or her.
Did you know that lawyer was that kind of lawyer? Did that take you by surprise?
No, I knew. I was prepared for that. But still, when it actually is in your face, it's not fun.
Yeah, yeah.
No.
Well, once they learn it doesn't work, they usually stop.
Yeah. I mean, I stood my ground.
You've been involved in the state bar
Mhm.
quite a bit. In fact, we're president of what's now called the Young Lawyers Division. Practicing law is a consuming way to make a living, and yet you still volunteer your time with the bar. Why?
Well, I will tell you this. I loved doing all the work that I did for the bar. I loved leading and serving. But I did have my first child while I was president-elect, and my second child while I was president. And after that, I took a hiatus from bar work because it was very difficult to raise a family and do bar work and practice law. Fortunately, I have a very supportive husband who's actually here with me today. And he's a lawyer as well, but he stood by me. And there are some people who practice law and have families and do bar work. I just couldn't do it all. I'm getting back into the bar work now that the kids are grown up and y'all's age. Coming back because I enjoy it. You know, it makes me feel good to give back to the community, especially the high school mock trial. I just get so fired up about that.
Why should these students get involved? I mean, they can get involved even while they're students.
Yeah, and I did too. I was the third-year class vice president.
We'll talk them into it.
Well, it just, I don't know. I never did this when I was in high school or college, but when I got to law school, I got an opportunity and to give something back to everybody else and to make a difference. I mean, that's what I was trying to do in everything I did, is make a difference and be a leader. I kind of miss some of the bar work, but it is all consuming, but it's part of what I think we do as lawyers. We lead. We don't just sit back. But I like sitting back sometimes, like with high school mock trial now, I just go to the competition and they tell me what to do. I don't have to run a statewide competition. I only had to do a very small competition.
Let me go back for a minute to the representation of lawyers in the disciplinary context. You mentioned that at the root of a lot of cases is alcoholism, drug abuse, things like that. If you had such a client, who really had committed some misconduct, but it was arising out of something like that, what would you do, if anything, to try to address the underlying issue?
Oh yeah, I would definitely try to do something. And there is the Lawyers Assistance Program at the State Bar of Georgia, and they will do interventions or help someone organize an intervention. And so I would probably seek the assistance of the professionals there that know how to do that sort of thing. And they also, the Lawyers Assistance Program is available to law students. And they help with a lot of other things too, like financial issues. I had one applicant for admission to the bar who had, I told him not to spend his money hiring me because he didn't have any, because he had not paid his student loans. They were in default. And you can't sit for the bar until you have shown, I think, for 3 months that you've got a payment plan and you're sticking to it.
6 now.
Is it 6? Well, he came to me and I said, look, you don't have any money to hire me. You're smart, you can figure it out. But I sent him to the lawyer's assistant program. Well, I mean, you know, why spend $2,500 on me when he needs to spend that to get his finances straight? So he went to the lawyer's assistance program, and I think they gave him some advice on how to get his act together. I don't think he's sat for the bar yet, but I hope he does someday.
Yeah, and the students will not have heard about the lawyer's assistance program until you mentioned it. Have you known lawyers who took advantage of that program?
Yes.
And what was their experience like?
Well, I know one lawyer did go to a facility called MAR, but ended up checking himself out of MAR. But it's difficult, and it takes the support of a lot of people around you, and it takes the support of your family and friends, because it's not an easy thing to go to.
One of the things I always do with people who are nice enough to come spend time with us is invite them, and I'm going to invite you now, to tell the students anything you think they should know. You've been a lawyer 30 years?
30 plus. Yeah.
30 plus, me too. Anything at all that you think they should know, any advice you have, something maybe you wish you had known as you were where they are?
Well, I still like the number one most important thing on your desk is an unreturned phone call or unreturned email or whatever. I also, as a litigator, one judge said this, and it stuck with me. Treat every person you meet as a prospective juror. And I always thought that, because you could lose a case because someone doesn't like the way you look, the way you act, just something real simple. Or I remember that lawyer, I saw him on the street being a jerk. So I thought that was a good one. And then this is something I was told early in my career doing domestic relations work, where it can be very litigious and the spouses already hate each other often. Never disparage another lawyer in front of your client. And that, to me, speaks to professionalism, but I was taught that my first day in private practice, is to, no matter what you said, you know, Betsy, we know this lawyer's a jerk, but don't say anything about it in front of the client. We just did no comment. So I thought that was really good. And then back to what I said before about the jerk, the guy who was a jerk to me at the deposition. If you've done your research, you're prepared, you know you're right, or you're pretty darn good argument that's sound, stick to your guns, don't give up.
How often have you been tempted to disparage the other lawyer in front of your client?
Not so much anymore that I don't do domestic practice, I will say that. Not so much anymore.
You sound very happy that you don't do that.
I am. But, I mean, the ones who do it, and the ones that I respect that do it, do a really good job, but not me.
Why?
I took it home. I personalized it too much. If they were fighting over the children, or, you know, I didn't like it. Or using the children as pawns. It just bothered me. I don't go home and worry about whether or not my mechanics lien is good or not, or, you know, if my client settled for $50,000 over, you know, they only lost $50,000. I mean, but they made a business decision, you know. People in divorce cases didn't always make business decisions. It was very, very personal. Yes. And as the lawyer that I worked with said, when you have a divorce lawyer or domestic lawyer, you really have, it's like having a personal physician. You have to emotionally undress. And people usually do. And you get a lot of stuff you probably didn't want to know. And people fling at each other. It just wasn't me. But if you do it, if you want to do it, and you've got a great personality for it, and you can close the door and go home and not worry about it like I did, my hat's off to you, because I think we need good domestic relations lawyers.
The students had a visit last week from Judge Sizemore, and Judge Sizemore liked to tell the story that when he would preside over domestic cases, what really bothered him was the custody fights where at the end of the day, he wanted to take the children home with him. And it happened all too often.
Yeah, I can see that.
All right, well, let me turn this to the students and
Okay.
see what questions they have for you this morning. Yes, ma'am.
Just to speak to underlying issues that lead to misconduct. With the rising cost of legal education these days and the amount of debt that, law students are leaving school with, have you found any kind of correlation between, the amount of debt that we're having versus instances or in relation to instances of stealing or thievery of trusts or things of the sort?
Well, that's a good question. I personally haven't, but I could see that could be an issue. As a matter of fact, I know we had a lawyer that used to share space in our office. And it was interesting, he did a lot of plaintiff's work, and he was not a partner in our firm, but my partner could hear him talking, and he could tell when his finances were bothering him a little, he'd be encouraging people to settle sooner. And you've got to be careful because you've got this professional duty to look out for the best interest of your client, not the best interest of yourself. But I could see that being a big problem, and I know because I've talked to a lot of young lawyers and third-year law students who are looking for jobs, and I know there's debt. I mean, I have two, one's still in college and one out of college, so I know about that. And so I think it could be a factor, and you have to be very careful that it doesn't become a factor.
I don't know if you've seen this, but in that connection, I've seen young lawyers who just take on too much. Just let anything that comes in the door because they're afraid that there won't be something else. Have you seen that?
Yeah, and you've got to be careful what kind of cases you take and how much you're going to charge and how much time you can afford to put into a case. But one of our other duties is to be competent in whatever we do. And if you take on too much and it's pretty tough to be a jack of all trades these days. I don't think you see as many of those except in the smaller towns. But even then, it would be a good idea if you're a younger lawyer, even if you're on your own, to find a mentor, to find somebody else that you can bounce ideas off of. My husband practices in a law office and shares space with other lawyers. And there's a lot of that around. I'm glad he's solo practitioner in an office with other lawyers. It's always good to have another lawyer. Even me, being a partner, my partner and I, we read each other's letters just to make sure that we've not said something incorrectly or wrong. It's always good to have someone who has your back.
Yeah, and this notion of mentors has come up quite a bit this semester. How important it is. Other questions? Yes.
I just wanted to kind of ask you about the dynamic. I know you said that you do the mock trial. I don't know how long you've been helping students with mock trial. Have you seen just from I guess that there might be some students that have essentially gone through mock trial and maybe gone through school and become lawyers themselves. I mean, I feel like maybe the passion would be that you can set like a good ground from the start. Do you find that is something that actually has like translated, or do you think that it hasn't necessarily?
I think you see both. I mean, there's one lawyer in my office. We were going to Lawyers Club together one night, and I said something about high school mock trial. He went to nationals. He was in high school mock trial. Loved it. I've talked to other people that after they did high school mock trial, no way I want to be a lawyer. It's too much work. So, but then another woman I talked to last weekend, she was going to go to med school. And then she did high school mock trial. And she said, this is what I need to do. And she's a prosecutor. So I think it goes both ways. And not everybody that goes to high school mock trial goes on to be a lawyer. But by the time you get in law school, if you're doing mock trial, you're probably going to be a litigator.
Yeah, and they'll have plenty of opportunities to do that as law students. So.
When going against opposing counsel and noticing wrongdoing on their part, what's our obligation to report that, and do you see it often?
Well, there is no mandatory reporting of misconduct in Georgia. I think we're only one of 3 states that does not have mandatory reporting. And you see a lot of lawyers say, I'm not going to get another lawyer in trouble. I'll never file a grievance against another lawyer. And I think I haven't seen any instances where I felt like I needed to file a complaint against another lawyer. But I think if it's so egregious that I saw it, I would consider doing it, because I think we sort of have an obligation to do that. And I wish more judges would do it, because I think judges see things. But I know a lot of judges that are afraid to refer anything to the investigative panel. And also, just to let you know, the state bar has investigators. And so sometimes the investigative panel or the state bar can initiate bar complaints on their own. I guess the most common would be if there was some sort of advertising violation, they'll send an investigator out to say, hey, they won't immediately file a grievance and say you violated the advertising rules, but hey, you know, you're not complying with the advertising rules. You need to change this. If you don't change it, then there's going to be a complaint.
Without it being mandatory, is it still a big issue? Do you think that for Georgia, all the attorneys kind of uphold the obligation on their own, or do you think they shouldn't be mandatory?
I don't know. I haven't really thought about that. I would kind of be in favor of making it mandatory. And that way, you would say, well, I really didn't want to do this, but I had to. It's not my fault. The bar rules made me do it.
So that you don't get accused of being, right? Well, and the students, you know, may be familiar with this syndrome, because our student honor code for students says you should report misconduct of other students, but there's no mandate to do it. So they've seen it from that point of view. And of course, the model rule, and the rule in most places, is you do have to do it. So, yes?
How have you seen the profession change since you became a lawyer, and maybe what do you expect the changes in the next 10 years to be?
That's a really good question. She asked me, if y'all didn't hear it, what changes I've seen since I started practicing law. Well, I didn't use a computer, didn't have a cell phone, and when I went into court, I don't anymore get, if I went in for the male partner in the firm, I don't get, well, you're a lot cuter than Mr. So-and-so anymore. Now, maybe that's because I'm not as cute as I was then. You just wouldn't hear that from a judge anymore, but I did get that. And things are a lot faster now. You know, the clients want everything now because they can get it now. And so instant stuff, you can't say, well, I'll get that to you in a few weeks. No.
Isn't there danger in that, though?
There is. You need some time to think, you know? And that's what I mean about talking to other lawyers in your office. I don't know everything. I think I do sometimes, but I find out if I talk to other lawyers, I get other ideas and perspectives. And I learned that in law school, actually. One thing I will, this is just my unsolicited advice, I'm a big believer in study groups. I never studied in groups when I was in college or high school or anything like that, but in law school, it helped me prepare for exams. I got ideas from other people that I'd never thought of, and it just helped me remember things that I could then put on paper. So I digressed. But still back to the same thing. Sounding boards, talk to other people, get other ideas.
What about the next 10 years? That was part of the question.
I know. Well, gosh, I have no clue what's going to happen. I mean, considering what's happened in the past 10 years, I guess, I don't know.
I don't either.
It's scary to think. What more can we do? I guess we're just going to have to get faster and faster and faster. Yes, maybe we'll get rid of some of the paper in the law practice. There is so much paper, especially as a litigator. Even though we exchange electronic files, when you go to court, you have to have the paper. You have to have the evidence. And I mean, it'd be nice to get rid of some of the paper. Do you have a question?
Yeah. How do you manage those clients and colleagues that want things from you instantly when you need time to think?
Well, that's part of client management and client expectations. And to just let them know up front, I am really swamped right now. I've got a trial right now. When your case is on trial, You will get this undivided attention if you've got something that you know, and sometimes you turn down a case. If somebody says that they need this done this week and this week's already full, sorry, I can refer you to someone else. But I think you have to give the clients the right expectations and let them know if it's a closing, whatever it is, that when your case is front and center, you'll get front and center attention. Or you've got 30 days to answer the complaint. I will get to it. I don't do everything at the last minute. I will work with some people who do, but I try to manage and say, okay, your answer's due in 30 days. I'll get a draft to you in 15. So I think you just have to manage clients, take control of clients. Don't let them, sometimes it's hard to do that. And especially as a younger lawyer, you're going to have partners you could have partners telling you what to do. But sometimes you have to stand up for yourself and say, whoa. And then they'll say, well, you've got plenty of time if you only sleep 3 hours a day. and don't eat, and don't have a family, and don't have a life. That's fine. Some people enjoy that. I mean, some lawyers I know come to work every day, 7 a.m. till 7 p.m., weekends, no matter what. And that's fine. I like to have my life. And fortunately I'm at a smaller firm right now, and I'm able to have my life and come down here in Macon on Sunday and spend the night over to Monday. Although I wish it would have not rained. I wanted to see the parade.
That's my fault.
There.
During your time prosecuting other lawyers, I can see how in some instances some may think or see you as the villain. How did that affect your relationship with others in the law community? Because I've come to understand it is a very small community. And if any, did it affect your relationship?
It didn't really. What actually happened to me, and when I first got offered the job, I called up another lawyer and he said, oh man, I'd go down there and interview the heck out of that job and get it, because I met the bar leadership. I met the review panel, the disciplinary board, the board of governors. I got to know leaders of the bar. So I never felt like I was anything but a good guy, doing the right thing. I mean, so I never felt like I was a bad guy. Now maybe people thought I was, but I felt like I had the full support of the bar leadership, and I got to know some people that I would never have gotten to know as a younger lawyer right off the bat, and still know today.
You ever get the sense that the direction that the bar is going with this, and with advances or steps forward in ethical inclusion, like what's going on in South Carolina, is that you ever get the feeling like the bar is going too far, like it's overreaching, it's getting too much into lawyers' personal lives, there's too much of a blurring between where the person exists and where the profession ends?
I don't see that in Georgia. Now, the South Carolina rule, that may be a little bit more difficult. Somebody's jerk is somebody's favorite lawyer. I mean, so I think that's going to be difficult to prosecute. But I don't see the state bar, I think, in Georgia keeps a very good line. Like I said, they don't get into your personal conduct unless it's a felony or a misdemeanor involving moral turpitude.
Well, sorry.
That's okay.
About the moral turpitude aspect of it, like I was a teacher before, and
Okay.
that's a big thing behind everything that teachers could possibly do wrong. Is you can break all the laws that you want to, as long as it doesn't involve a crime of moral turpitude. You can rob a bank, that's fine. But getting into that aspect of it, I mean, like there's lots of attorneys and lots of lawyers out there that do lots of things that are completely against the law, and they still are in great standing with the bar association, and I'm assuming that's because they pay their dues on time, regularly or something. But that person you're talking about getting questions like where they have to go to a psychiatrist and present all this information that says that, no, I swear to God, I'm a good person. I'm okay now. I'm fine. And having to put all that information forward, that's not. You don't feel like that ever overreaches. You're really getting into somebody's personal life.
So particularly in character and fitness, you mean?
Yes.
Yeah. Well, I was surprised at that, personally. I was. I thought that was, but I've talked to someone who's on the board to determine fitness, and he's enlightened me that there's been a lot of cases. And the thing is, they're getting into it, but we still have tons of lawyers. And they're not getting that many disbarred. So I was surprised, though. I was surprised at the depth in which they went into because I don't think they went that far back in the day. If there was just, I mean, a DUI and a non-criminal offense, that you have to give your whole drug history, and for that, I was a little bit shocked. So, but they feel like they need to, and maybe they're trying to, for a while there were just so many people applying for admission, I think, and to law schools, and that's tapered off now. Maybe they'll back off now that it's tapered off, I don't know.
No, some of it's cautionary.
Get them before they come in, yeah, so.
Well, I'm sorry to say we're out of time,
Okay.
but join me in thanking Betsy.